Yes.
My Lord, the first point I make is this, that the learned judge used the words non-fraudulent defendant in his judgment, his second judgment, in which he talked about giving permission to appeal. My skeleton explained that those were his words. There were two other potential grounds put before the learned judge, which he rejected. I say that for the purpose of this appeal, it can mean only that it's a party as regards which one cannot pass the RBS test. That must be right. There were no findings against Mr. Butcher in the original trial by the Honourable Judge Bird. His judgment was simply that we had to succeed against Outlook in order to succeed against the other defendants. Certainly no findings of dishonesty or fraud there, or in Mr. Justice Kerr's judgment. Indeed, it wasn't any part of our case. I say we made that clear rather early then, but we certainly did at trial that we were not suggesting that he had given conscious and deliberate dishonest evidence. So I make this further point that one of the difficulties there was, of course, the learned judge's judgment, His Honourable Judge Bird's judgment, didn't mention Mr. Butcher at all, and it would have been very difficult, even if we had had evidence of any form of withholding evidence or the like, to say, well, that would necessarily have changed the way in which the judgment actually went, because one has to look at the judgment itself and not at the parties. One's looking at whether that particular judgment has been obtained by a fraud, and I'll develop that, but I say it's by the fraud of any party. And indeed, there's authority which suggests it can go even further than that. I make the point about not being any findings against Mr. Butcher or the like, because points made both at trial and in the skeleton mention the fact that the impact of the judgment was to find or to render Mr. Butcher liable for the fraud of another. That doesn't appear to have been developed in any different submissions, but I simply say that it would be a hopeless point, because there's no way in which either of those judgments found him liable for anything. Indeed, all that Mr. Justice Kerr's judgment did was to take us back to square one on the grounds of the judgment which had been obtained in Manchester. Again, points made in my skeleton, but just to emphasise that the claims against Mr. Butcher in the original proceedings had nothing to do with fraud, and none of them require any element of fraud or dishonesty or the like. They were claims for trespass, for conversion, and a duty to account in relation to any recovery over and above what was actually owed. Well, in terms of conversion, again, my other friend didn't make the point in his submissions, but he's referred in his submissions to that part of Balsted and Reynolds on an agent who simply undertakes ministerial acts. If I can just...
But as you say, that argument wasn't pursued, so it's not.
Yes.
Right. So he helpfully confirms it's not pursued.
It just... well, the way that he approached the new evidence in my submission was completely correct. And if I can invite you to go to the RBS judgment first at page 237 of the authorities bundle. And RBS was a case where there had been a subsequent trial, and Mr. Justice Burton decided that, with the benefit of hindsight, and that's at paragraph 140, it was actually a compelling basis on which to say, well, it wouldn't have made any difference. And what Lord Justice Aiken go on to say at paragraph 41 is this: I cannot accept this argument. In my view, it's necessary to concentrate on the only judgment that is said to be impeachable by virtue of a fraud by RBS, i.e. the liability judgment. And he then goes on just to go...
I must be in the wrong place. Could you give me the reference again?
Yes, it's page 237 of the authorities bundle. I'm very sorry, behind tab 11.
Right, thank you.
So I was reading from 141 my lord, that one has to concentrate on the only judgment that is said to be impeachable. And then just above letter F, he says, I agree with the analysis of Sir Justice Langley in Sphere Drake Insurance that the materiality of the fresh evidence or the new fact relates to whether the original judgment is therefore impugned. It's not for the judge considering the issue to retry the question of liability or to see whether the fresh evidence or the new fact is material to the final result. And so that's exactly, I say, exactly the way that he approached the new evidence in this case. And if at page 348 to 349, which is within the decision of Tinkler, which is tab 14, he first recites that same passage from the RBS judgment, and then he goes on at paragraph 38 of his judgment to say, as I've already said, the questions of A, establishing whether there was a fraud, and 2, materiality, are interrelated. I would endorse the description of position in Grant and Mumford. The requirement of materiality does not extend to the second court having to retry questions of liability, or to see whether any fresh evidence or material to the final result in the sense of influencing what the decision would be if the matter were to be retried with honest evidence. Indeed, the second court should not undertake such an exercise. The purpose of the second action is to take the parties back to the position as it was before the trial, so that a new trial on honest evidence can then take place. But he then goes on to say it's in practice difficult in deciding the question of materiality for him not to trespass to some extent on such matters. And so if it's the right that one takes the parties back to the position before the original trial, and that original trial was a success for all of the defendants based on what is palpably found to have been dishonest evidence in a large number of respects, then that, in my submission, is the case in relation to all of the defendants, unless, and I'll come on to explain that, unless it's found to be an abusive process. And in my submission, the authorities are in fact in unison on that, and I'll explain briefly that despite the considerations of the Supreme Court and the Privy Council in 2 very recent cases, they have not been able to identify any area which one could describe as a no-go area. And my Lord Justice Singh observed, and my only friend accepted, that the effect of his submission would be to draw such a line. It would be to say that there cannot be a case in any circumstances where the party that has not been fraudulent can ever have that judgment set aside, even where, in a case like this, its success didn't rely on the fraud as such, but the outcome was only as a result of that very same fraud. And in my submission, that would be a remarkable situation. And that this case is, in fact, nothing more than an incremental, not even a development. It is the first time it's come before the court, it appears, but it's simply an application of the law as it stands, a law which says that the equitable jurisdiction, which is where we are, has to retain flexibility and to adjust to situations or new situations which come before it. And at page 352 in particular, he goes on at paragraph 44 to say, in my judgment, let me just let you find it, I'm very sorry. So page 352 and paragraph 44. In my judgment, however, the judge was right to concentrate on his consideration of whether the alleged concealment of the new evidence established that there had been a fraud practiced on the court. As Aikins put it, the judge's task is to see whether the new evidence impugns the judgment and whether it shows that the previous evidence was an operative cause of the court's decision or would have entirely changed the way in which the first court approached and came to its decision. And again, I say that the new evidence does impugn the original judgment, and that it establishes that there was a fraud practiced on the court. And there was, I think, a reference during my learned friend's submissions to the question of whether it's akin to deceit. The learned judge actually dealt with that and said, I don't think that's right. I think it's a separate jurisdiction, a separate cause of action to impeach a judgment for fraud. And, my lords, I was at pains to explain to the learned judge that I didn't think that words procured by fraud or obtained by fraud were particularly helpful, and that tainted by fraud was a more appropriate use of words, and he agreed with that. Because actually it's looking at the words procured by, obtained by may be correct if you're looking at a two-party situation, but there's a lot of authority in my submission which makes it clear that it is much wider than that. And one is looking at has the fraud had an effect on the judgment? And here it's very clear that it had the same effect on the judgment against Outlook, or sorry, the judgment against Mr. Butcher, as it did against Outlook, because the one followed from the other. So, well, I say that where there are, as there are here, findings that the original judgment did result from fraud, and, my lords, I just make reference to the judgment for your note at paragraphs 83 to 84. That's where he sets out, I find conscious dishonesty, I find that it was causative, and I find that it would have changed the way that the judge approached the evidence. Where the extent to which the court was deceived was so significant, and I say this in relation to that Lady Fred made reference to the fact that the bank was somehow significant in our original case. It was an admission that was made by Mr. Fradgley. The judge actually effectively gave him credit for that. He said, well, he's been completely open about that. But then I go to the documents and I find that all the documents seem to stack up. And so I'm going to believe it's not right that we were relying on that. It was a potential, I wasn't involved in that trial, I should hesitate to add, nor in Scotland. But what happened after that was a very large number of additional factors which arose. But it is quite clear, as I say, that the case against Mr. Butcher was dismissed simply because we lost against Outlook. And in those circumstances, to suggest that it's first that the jurisdiction doesn't allow the court in those circumstances to adjust to a new situation like this would be a right remarkable one in my submission, indeed. And moreover, the reasons that he gave, although my friend, I think, has accepted that the judgment, the appeal is very confined. It's simply to the existence of the equitable jurisdiction, not his reasons for giving it. In terms of the question of when we had the information, my friend made some play about the fact that we had evidence at some earlier points that might have shown that there had been some extra issue with the documents. And like I say this, some small discrepancies in the documents did not in any way assist us to show how much was owed. One may say, well, there's a board minute there, I never went to that meeting. But the plea of fraud was only made, and I think it's important to understand this, we only amended, sorry, my clients only amended their claims in Scotland to assert fraudulent representation in relation to the monies due and in relation to the alteration of documents after the Henderson-Logie report. And I say that's material, and the judge equally found it material. And if I can ask you to go to his judgment in core bundle, page 74.
We're on ground 2, are we now?
I'm sorry?
Are we on ground 2 now?
Well, no, I'm simply setting out what his findings were in the more general sense at the moment.
Is this relevant to ground 1?
It is relevant to ground 1 and 2. You're absolutely right. And so at CB 74, paragraph 175. For completeness, I reject the submission that a retrial of the claim against Mr. Butcher would be an abusive process. They were unable to obtain a determination of the claim on its merits because of the fraud on the court perpetrated on Mr. Fraser. They did not have in their possession the material necessary to expose that fraud until at the earliest 2019, when the Henderson-Levy report was obtained. And so, well, you asked the question earlier on, Mr. Zacaroli asked the question of how did this all start and what the process was. For that, I ask you to go, please, to the judgment at 143 to 148, where he makes a number of very important findings. So he makes the findings of under RBS at 144 to 146, and over the page, it's page 70 of the bundle. Most of the evidence subsequently obtained, enabling the Lindsays to ultimately unmask the fraud, was not available to them in the Manchester proceedings. So that's a finding of fact, which is not in any way challenged in this appeal. He then goes on to say, I accept that there was a causative effect, and he says the favourable impression Mr. Franklin made on the judge would have been unthinkable. And he then says this, without the fresh evidence, there was no basis for alleging fraud against Outlook. It was not remiss to refrain from deploying such allegations in the Manchester proceedings. On the contrary, on the information then available to them, it would have been untenable and wrong to do so. Mr. Fradley was very plausible. It's entirely understandable that the action proceeded on the basis of estoppel and waiver, etc. And then he goes on, I accept the claimant's submission that a retrial against Outlook wouldn't be an abuse. It was their continued attempts to extract money and land from the Lindsays, which eventually provided them with the evidence they needed to unmask the fraud. I do not agree that the Lindsays took too long to obtain the fresh evidence and to secure the findings of Lady Wolfe. It was necessary to proceed step by step with dogged tenacity and determination, and the Lindsays did so. And so, well, I say none of those factual findings are challenged in the appeal, my submission, that's very significant. And so, when one of the points raised by my own friend Skeleton, and again not developed, but he does talk about us having all of the evidence, is a reference to some of the, a reference in his Skeleton that there was a one throwaway line in paragraph 176 where he says, well, I think the defence of late is made out. But I say that's entirely unfair, and in fact the judge was very, very clear, and he was very penetrative in his own questioning, which I'll show you in a moment, in terms of what exactly went on and how things moved forward. Lord, he refers to a section called How We Got to Lady Wolfe. I think we saw the beginnings of that during the course of Maloney Friends submissions. That section goes from paragraph 48 to 125 of his witness statement, and it was inserted because of the fact that the Leitch's defence was raised in September, just about a month before the trial, but my learned friend Junior, who was in the trial, maintained that permission had already been given by an order of Master Sullivan. I'm not sure if your lordships are aware of that part of the story, but what it meant was that it was agreed we'd have to deal with it on the first day of trial. And so we put in a much longer explanation of every step along the way. And the judge said in the clearest terms, I take that fully into account in reaching my judgment. And obviously the findings I've already shown you show that that was the case. And can I just ask you to look at some of the extracts from day 4 of the hearing. Day 2, which is when my client was being cross-examined. And that's at tab 8 of the supplemental bundle, and it starts at page 100. Well, I start on page 100 because what happened there is that I started off on the top left-hand box asking about delay generally, and the judge interferes at page 15 on the internal numbering. I don't want to stop you. I'm afraid I'm going to have to. I fully appreciate what you're saying. You're going all the way back to 2012. And then he goes on at line 15. I'm afraid I'm going to insist you focus on the time that you took to bring the current action. That's the point. Then on the next box on the top right-hand corner, Mr. Justice Kerr again says, well then, and the answer is the document refers to a period of 10 years. Your witness statement sets out the events over those 10 years, doesn't it, Mr. Lindsay? Yes. And in terms of the timeline, it finished in 2014, yes. And it's being suggested that you brought actions in relation to Harperfield. Can you explain how that went ahead? And again, the judge butts in and says, sorry, this is all there in writing. So he's got that. He says there's very little, almost no challenge to that part of my learned friend's, my client's witness statement. And what Roger Lindsay says at line 7 on page 21 is, my lord, my simple answer is that we were constantly working toward proving fraud. Everyone knows the very high levels of proof we had to get to. We had a very high bar, and Lady Wolf's judgment proved that was delivered. We couldn't have done anything any quicker than we have to get back here. And the judge says that's very helpful. Then over the page, my learned friend, Mr. Banks-Jones, on the top left-hand box at page 26, internal numbering, at line 21. Could I ask you to turn to page 52? You say the new evidence is all evidence which was not used before Bird. And then you go on to say, and some of which is in a couple of boxes, which I put in an outhouse in circumstances below. Now, when you say these were not used, I think you mean that you had them in the boxes and they weren't disclosed. And he says that's correct. And I then intervene, and of course one doesn't want to intervene in these situations, but I intervene and I say, can I just make clear which part of the statement is referring to? Because there's a box of documents, but it's clear that the statement he talks about is evidence which came around from the Scottish proceedings. My learned friend, I think, is simply trying to get the point that he had all the material but did not use it. But it's very clear from the middle of that paragraph that there are a number of different types of evidence. And the judge said, let me just read it. And he says, actually, you're right. It leaves open, does it not, whether the boxes fall in this category or that category. And so then at the bottom of the bottom right-hand box, just before the end at line 22, my question is, this is my learned friend questioning him, knowing what you knew and the need to disclose, why didn't you disclose them? And his answer is, over the page, they weren't relevant to the issues. And the judge acknowledges that. And then page 31, Mr. Justice Kerr says, are you going to tell me what's in the boxes? Again, saying that he's forensically examining me. He wants to know what's going on. And what he says is the boxes, what was in them was invoices and stuff, and then in between, without any rhyme or reason, there were bits of agreements, copies, just signature pages, nothing you could make sense of. There was a document in there that turned out later on that further signature was the one that Lady Wolf found was forged. So when the learned judge interferes, I intervene. So I think the answer, Mr. Banks-Jones, is that they became relevant later, but they weren't regarded as relevant at the time. He then goes on to say, when his friend questions him, what I want to ask you is, these lease agreements, etc., you were challenging the right frankly, under various different loan agreements to take possession. Why did you not disclose them? He says, you're mistaken, Mr. Banks-Jones. It was the collateral agreement that he made with us that as long as we paid the interest, there was no challenge to the agreements. And then the question is, at the time, you believed the agreements were correct and there was no challenge to them. We did. And so then Mr. Lindsay says at the bottom of that page, an important part, importantly arose from Outlook's own expert, who was the only person who was given access to Outlook's sales ledger books and cash books, etc. I mean, my client's witness statement explains that, firstly, there was significant difficulty getting hold of documents from Outlook in relation to disclosure. And when the Lindsays turned up with their expert to have a look at the documents, Roger and William were refused entry. Their expert was allowed to go and look at some of the documents, but even they didn't see all the documents. And so, that's what pulled the picture together. And I've shown you the finding of Mr. Justice Kerr, which was that we didn't have that information until much later. On page 103, at line 7, my client has just been reminded about that we got hold of some bank statements in 2015. And you say that these showed that he'd lied in Manchester. Why didn't you do anything about it? For 8 years. Now, the argument or the submissions made have rather changed over time. There was a reference in the original defence that it was all unfair because it was 10 years later. And if you've looked at the first day's extracts, you'll see that I said, and the judge said, are you saying all they're doing is just moaning generally about delay? I said, I am. And what they need to do is they need to set out exactly what the time period is, what it is that they say the prejudice arising from that time period is. And so we start off with a pleaded case which just said in a number of places it's 10 years and it's all unfair. We then have this, you did nothing for 8 years. Now on that, the judge again intervenes and he says that's a difficult question. There's a disputed premise in it, which is that they did nothing for 8 years, which I'm quite sure the witness doesn't accept. And then the question then is, why did you only bring this claim when you knew about things in 2015? And Mr. Lindsay responds, Mr. Banks-Jones, that information was only proven to a point where fraud was proven. Those were just one small part of the information, and that judgment was in 2021. And you've got to get in context, Mr. Banks-Jones, that after Manchester, from 2014 to 2016, we had been fighting litigation, and we raised the action for declarator or reduction of the loans in early 16, 17. So he's really saying there that from the time of the Manchester judgment, it actually only took a couple of years for them to start the declarative proceedings in relation to the two loan agreements. And then later on, he explains that having got judgment in August 2021, and in fact, that was then, unfortunately, having had a judgment against them, Outlook went into liquidation two months later. That it was only from September 2021, and to answer a question Lord Justice Singh before lunch, there was a letter before action in October 22. So that was just over a year from Lady Wolf's judgment. They had to, of course, they succeeded, but not only had they had all the costs of the Manchester action, but they'd spent money on fighting the Scottish action, which they should have got a financial reward for, and their costs. They got nothing because Outlook went into liquidation. So they had to find someone to fund the case for them, or to find money themselves. they then had to instruct myself, who had to catch up on a 200-page odd judgment and all that had gone before. And in my submission, that itself was a very commendable period of time in which we brought that second action. So, but it's just a moving feast as to which periods that we're talking about. But what Roger is saying here is the suggestion that a bank statement which showed that we might not have been paid the full amount of £200,000 or the like, that could be a mistake. We don't know. I can't say that that's fraudulent. That was only ascertained, and we only amended the claim in Scotland to assert fraudulent representation after the Henderson-Luggett report in February 2019. Well, in terms of the question of the time, I think I mentioned about the difficulties that were faced in disclosure and generally. In closing submissions, and this is at tab 10 of the same bundle, it's at page 127, and it's my learned friend's submission if I start at page 27, that leads on at line 5. That then leads on, my lord, to my key final point later in the day, and that's obviously the latest defence. There was clearly, to start with, don't think this is disputed, all of this raised its head many, many years ago. Sorry, after the event. There's perfectly good opportunity, as it was thought appropriate, if not to join Mr. Butcher, certainly his associate who had acted as a receiver over the Scottish farm. He then goes on to talk about the difference between what happened in Scotland and what happened in Cumbria. And I can take you to the extracts if we need to, but basically that there had been a coordinated attempt to take both farms. Mr. Butcher's colleague, Mr. Woods, was tasked with going to Scotland, and the judge is very critical of the fact that documents which were disclosed only in these proceedings in the summer of 2025 showed that before he actually took possession, there was legal advice to say, if there's any objection whatsoever, you should leave and get a court order. And my client makes the valid comment that there's all this suggestion about extracting documents and like, if Mr. Butcher had disclosed the documents which showed that he'd actually been told not to go on site, and had disclosed the documents to show that it certainly looked like, if it wasn't absolutely clear, that it was DM Lindsay that was the tenant on that farm and not Metalbridge Dairy Farm Limited, then none of this would have happened. But I then want to show you the passage on page 127 in the top right-hand box, and it's prefaced by the last few lines of the previous page. Mr. Banks-Jones, well, my lord, in terms of late sheets, all of the things that it is said were known occurred upon the mysterious box that was kept in the shed coming to light. And it said disclosure there, and the judge intervened. The disclosure in the Scottish proceedings, the claimants say, was like blood from a stone, and it wasn't the documents in the box, was it? So he's clearly, the penny has dropped, that the box has got very little relevance at all. My client has explained that it's just a complete mess. There's odd pages here and there. And when he went back to the documents a few years later, he actually found buried at the bottom of one of the boxes, and it's all in his evidence, this one document which suggested that there'd been a meeting in Stourport. But that's a tiny part of the jigsaw, and he's explained that very well. And the judge has picked up on the fact that trying to get disclosure was extremely difficult. And again, if I, in your deliberations, please do look at how we got to Lady Wolf's section, because my client explains in that statement that they asked for documents, they were refused, then they finally made an application, and they obtained an opportunity to go and see those documents. But that itself was another period of some substantial time. And I think when Justice Zacaroli said, how did this all start? In that same witness statement, which is in the supplemental bundle in tab, it's 14, I think it's sub-tab 2 is the way it's the bundle set out, but it's page 205. And he starts off in 49. In December 2012, weeks after taking possession of Metal Bridge, Outlook in Edinburgh called up the Harperfield mortgage, that in Scottish is sought to enforce the Harperfield mortgage. Then they got an interim costs order for £60,000, that's paragraph 50. During the late summer of 2014, we received a second calling up on Harperfield from a different firm of solicitors. Then at 52, they then tried to get a statutory demand against Euan's estate in 2014. They also had the allegation in relation to the cattle and the police. Then in paragraph 56, around the 17th of October, Outlook and Butcher issued a charge for payment of their costs orders. And then at 57, the next thing that happened was in late 2014, early 15, Outlook raised 3 actions against the Lindsays in the Court of Session to challenge the notice of a right to tenancy, against Euan's estate for possession of Harperfield, and against William personally to enforce an indemnity. And so, and he goes on to say that this is all done at a time when Mr. Fradley was still alive. They'd sold the farm, they had all of our money, and he explains very clearly that this was our farm, our machinery, our cattle, it was our income. Our income had gone. And what the learned judge also did quite effectively in the questioning of my client is to understand the difficulties my client had in terms of when they were and weren't represented. I don't know if you've had an opportunity to look at that, but it's in the same tab in about day 2 when he's being cross-examined, and it's put to my client that at all times he had representation. I'm just going to so he page 110 internal page 113 on the bottom right hand box, line 7, you've explained that in terms of the beginning of the declaratory action, you're acting as party litigants, which would be the same as litigants in person. And in terms of the action which he brought against you, how did you manage those in terms of representation? And he says, those were done by solicitors. We had some money at that time. We were able to fund it to a degree. We got help from friends as well. It goes on to explain in these passages that there were times when they had no representation. They put in a handwritten appeal out of time, which they wrote out themselves, which didn't get anywhere. And at other times they had funding. And those are real concerns in times of why the judge found that he did not find that they had taken too long, and why he found that they didn't have all of the evidence available to them at that time, which in my submission cuts across the submission that Learned Friend made, that we manifestly had all of the documents, there was no new evidence. In any event, there's no appeal against any of those factual findings which form any part of this appeal. So, my learned friend pressed hard on issues of delay in his cross-examination of my client. He tried to show that he'd done nothing for 8 years. He tried to show he had all of the evidence. And the judge very much explored those factors for himself. And he came to the view at, I think it's page 106 to 117. It's where he says, I think the way one would describe it is it takes time to turn a ship around. Let me just find. Yes, it's at page 105. So if I can just go back to a passage that my only friend referred you to on page 104. Line 9, we raised the actions in 2016. Those were the actions based on circumvention, duress, effectively. Then he goes on, they concluded in 2016, they lost their cases. They unravelled, and the cases went against them. We then accumulated the evidence. We raised our actions in December 2016, which is a matter of a month or so. We then raised the second declaratory action. I don't accept that there was any delay. We could have done anything faster. I mean, going back to where we started, Mr. Banks-Jones, the level that we had to go to prove fraud, the bar you've got to meet, it was a step-by-step process. And the solicitors were, you know, they were gentlemen to plead fraud in it. And the judge intervenes. I think the tenor of the answer is that it takes time for the tide to turn, and to turn a ship around like that does not happen overnight. And that's very, that's effectively what he found in his ultimate judgment.
But this is referring to 2016.
To?
This is referring to 2016 and 2017.
Yes, that's right.
The fundamental point Mr. Wardle makes against you is, well, if you could do that in Scotland, why couldn't you do it in England?
We had to get a judgment against Outlook before we could come back and bring a claim in these proceedings. In this submission. And it's certainly not part of the pleaded case against us or any of the references to the skeleton argument. So that is something which we could and should have done. And I add that the original actions in 2016, my lord, and this is important, they were in relation to the circumvention factors of going into the farm with Euan Lindsay on an oxygen machine, suffering from farmer's lung, when Mr. Fradley knew that the boys, as he calls them, that's Mr. Roger and William, would be out milking, and told him that if he didn't pay £2.6 million then and there, the bank would be after them. That is something which did not go to the agreements, the loan agreements, or to the reason why Mr. Butcher was put into possession. That only came about as a result of the fact that we found out that actually we didn't owe 2.6 million. We owed an awful lot less. And you'll have seen that the findings of the experts were no more than 900,000 was owed. Mr. Lindsay explains in his oral evidence under cross-examination that since those agreements were unenforceable, the family had paid about £350,000 in payments since then. So actually that brings it down to more than £500,000. And there are a number of factors in the Henderson Loggy report which will say, well, actually they should come down rather more than that. But there is no, we never had to face a case of saying, well, you should have joined us or brought separate proceedings against us. And the judge was satisfied, and they've challenged to it, that we had to go through that process before we could then come and unpick the judgment here. And it doesn't alter the fact there's been, I think, suggestion about different types of issue estoppel and could we have brought an appeal. It doesn't alter the fact that this is a self-standing cause of action which we are perfectly entitled to bring. I mean, your question also goes to the question of the second ground of appeal, which is about late fees and whether there's been any detriment and the like. So the fact that we might or might not have been able to do so, which I'm not sure we could have done before 2019 and the Henderson Loggy report, doesn't prevent us from having brought this cause of action, because we've established that the judgment was manifestly obtained by fraud. The next part I want to make is whether or not this is an extension of the law or new law, or whether it's just an application of the law as it stands, and I submit that it's a sound application of principles which have been embedded in the law for a very long time, and that the recent case law is perhaps a recognition of the need to have the degrees of flexibility and ability to adjust to new situations, which have been referred to in a number of the authorities. And you were taken to the passage in, I think it was Mr. Justice Millett at the time, when he gave his judgment in non-roan fired, which was simply an endorsement of a passage in Moore, Gummer and Lehane, where he says the court has to remain flexible and be able to adapt to new situations which come before them. And the suggestion that there should be any no-go area, in my submission, is one which doesn't stand up to scrutiny, and one which there is no authority at all to say that there is any no-go area at all. And this is a perfectly good case. In fact, it's almost a paradigm case of saying why that jurisdiction should exist, where you have a party who only succeeds as a result of another person's fraud. How can it possibly be inequitable in a circumstances such as that to do so? Well, my learned friend conceded or accepted in his submissions that the appeal goes only to the question of whether the jurisdiction exists at all, and not into any realms of the extent to which, if he was right to find that there was jurisdiction, that he would, but that he erred in any way in coming to that conclusion. Lord, I asked for the submissions and the learned judge's second judgment to be put into the bundle, and that's at the very end of the supplementary bundle, behind, I think, sub-tab 5 of tab 10. The page I want you to go to, please, is page 274. And on paragraph 51, as to the first ground, I accept that my decision extends to setting aside against a non-fraudulent party is not covered by previous authority, and is an extension of or incremental development of the law. And I think that's correct. I don't think it's making new law. It's simply an application of the law as it stands. And he rejects that. The second one over the page is whether in the context of an action to set aside a judgment procured by fraud, an innocent and honest party may be held liable for the dishonest acts of another. And the judge then says this: I don't like that formulation. It sounds like vicarious liability. The issue is how far the equitable jurisdiction extends. So simply to show that the concession made was absolutely right. We're only looking at that very narrow question of the extent to which the equitable jurisdiction can go. And I therefore say that although there are points which are raised in my learned friend's skeleton in different guises, but in relation to the permitted ground as well as the other ground is any suggestion of finding liable for the fraud of another, which doesn't seem to have been pursued. Any issues relating to D3, because part of the skeleton argument talks about the fact that it's unfair, it can't be right, that you can decide to pursue one party rather than the other. That was, in my submission, that was a decision that I took. Why should we be forced to sue all of the parties? If, for example, Outlook had been a company of great value and say Mr. Butcher was uninsured, well, we would have just gone for Outlook. Why would we have to drag all of the parties into the proceedings? And the learned judge, and I said, if we had done, you'd have had to set aside against everybody. And he agreed with me on that, but he said, you've got to give them that first base of notice and an opportunity to defend themselves. And he does that by reference to one of the old Australian authorities, which I don't demur from, and neither does my learned friend. The bar in establishing fraud in the first place is a very high one. We all know that. And Lord Sumption makes that point at paragraph 64 of his judgment in Takar. And he says at paragraph 67, I mean, you've seen these passages, obviously I can take them back to you, but it's where he explains that he thinks that the concerns about frivolous and vexatious satellite litigation will be hopefully sensibly controlled by the high bar of fraud in the first place, the very tough test under RBS that it's not just a fraud, but a fraud on the court, and a fraud on the court which is causative of the original judgment, and the duties on counsel. And my Lord Justice Arnold asked about that, what happens in a situation where you have someone who's not represented. I think it probably only looking at the norm where one would have someone, a lawyer, pleading the case, and that they would know that they shouldn't begin to do so unless they are quite satisfied that they can. And Mr. Lindsay has explained that he went to see counsel a couple of times, and the solicitor kept saying, "You're not going to be able to. You've got to do more than that. You can't just say there's one document here and one document. You've got to establish. You've got a much, much higher bar than that." But once one gets to fraud, then I don't seek to say it's an open sesame to everything. I don't think I can disagree with Lord Leggett that that's correct. But where is there really a situation where one says, when you've established fraud and a fraud on the court, that there are dark line places where you can't go, no-go areas where you simply cannot tread? In fact, the courts say the opposite. Once you've got fraud, there's no different types of fraud. It's fraud. You've established fraud, and it's an extremely difficult thing to establish, and a fraud on the judicial process, effectively. And that's why the earlier passages I showed you, so you're looking at the judgment, not looking at the parties or the party that's caused the judgment. And the learned judge makes that point himself, and I also repeat the points made during my learned friend's submissions, that this is the enforcement of a substantive right. And so the judge, next part of my submission is this, that there was clear juridical basis for the court to make the findings that it did. And I just want to briefly go through the authorities, some of which you referred to.
Just before you do that, Mr. Bacon, can I ask you about the judge's judgment?
Yes,
on this topic? Something we briefly touched on this morning with Mr. Wardle. If you go to page 70 of the core bundle,
yes,
and my Lord Justice Zacaroli drew attention to paragraph 151, that when he turned to Mr. Butcher's case, the judge said that the second and third requirements in Royal Bank of Scotland do not logically arise, because he took the view that they really depend on the first one. But later on, I was interested in paragraph 154, where the judge said that this, I think, is the point you've been emphasising, yes, that the setting aside of the judgment is not done to punish the fraudster, but to protect the integrity of the legal process. And he said this: the tests propounded by Lord Justice Aikins in Royal Bank of Scotland are directed not at the parties, but at the impeached judgment. They address the grounds for setting aside the judgment, not the identity of the party against whom it must be set aside. Now, I think you would place some reliance on the reasoning of the judge at 154, I imagine. I'm just wondering if there may not be some tension between what the judge was saying there and what he was saying at 151. It may not matter, but I just wonder how you put your submission. Do you say that the Royal Bank of Scotland tests second and third one just don't arise, or is it better to take the view that actually they do arise, but they go to...
When you raised the point
judgment.
this morning, it was the first, I have to say, it was the first time that I could see how that might, well, I'm not sure how much it matters. One of the, can I just make this point? When we got the new disclosure in the summer of last year, which was worrying. I mean, with respect, you'll have seen what the learned judge says about it. They were advised by lawyers. They just made a positive decision to disclose that potentially privileged material, which said you shouldn't go in unless you have a court order or their express consent. And if they do consent, then get back to me and I'll draft a document for you for them to sign. That within 3 days of going on site, when Mr. Butcher was seeking to look at the milk supply, he found out that actually the milk supply, all the cows and everything was all actually registered to DM Lindsay. He didn't do anything about it. But that hadn't been a material part of the previous judgment. In my view, and that's why we're here, I felt that we didn't need it. It would have led to a significant delay in amending our pleadings. Would it have been possible for us to show that that evidence had impacted his judgment when the real evidence was the fact that Mr. Fradgley says, hands up. I lied about a bank, but in every other respect, I was completely honest with the Lindsays. So I'm not sure that it's matters, and it's an interesting question, but I'm not quite sure where it goes in relation to this appeal or what relevance it has. But I'll try and mull over that while I carry on with my submissions. I was going to take you to the authorities.
Yes.
The first tab was, these are obviously all in historical order, which is helpful, is Taylor and Salmon, a decision of 1838 of the Lord Chancellor at the time. And it's the passage at page 5 of the authority bundle, starting just by the first hole punch. If you've all got hard copy bundles, that is so. The appellant, however, sets up certain objections to the plaintiff's title to a decree. And first, he objects to all the members of the company on whose behalf the bill is filed are not parties to the suit. I've before taken occasion to observe, and he refers to a previous case, that I thought it the duty of this court to adapt its practice and course of proceedings as far as possible to the existing state of society, and to apply its jurisdiction to all those new cases which from the progress of daily making of the affairs of men continually arise, and not from too strict an adherence to forms and rules established under very different circumstances, and that which therefore decline to administer justice and to enforce rights for which there's no other remedy. So that's a very clear and very early sign of the fact of the need to retain that flexibility. We then have the Hip Fu Yong decision, which my friend took you to. Simply remind you that what it says there is that you have a different set of rules, or it's a different jurisdiction altogether when you're talking about a fraud on the court, and that a judgment that's tainted and affected by. And that's the words that I focus on. It's on page 894, it's page 45 of the authorities bundle. And I should point out that in Genesco and Beard, it was pointed out that this was actually an appeal, rather than a case to set aside judgment for fraud. But yes, he says in that very important passage, a judgment that is tainted and affected by fraudulent conduct. Is it not clear that this judgment against the decision in favour of Mr. Butcher was affected by that fraud? My submission it is, and he says that it's tainted throughout and the whole must fail. Now, again, it wouldn't be necessary to say that as against the fraudster, because the fraudster's going again. He's saying, no, it's tainted throughout and the whole must go. And I say that's subject to any suggestion of an abusive process on a case-by-case basis, but that's what he said there. We then have...
I think it's fair to say, isn't it, that neither in that case nor in any other was the question whether it affects innocent third parties.
Not directly before the court, although I'll take to some dicta which again suggests that it's a little wider than the friend suggests, or what would be required for this.
Just before we leave that decision, again, I'm interested in words like tainted,
yes,
and affected. In the Royal Bank of Scotland case, I'm interested in the phrase "an operative cause,"
yes,
because that again, it may give one an insight into what the correct principle is, which is at work in this area, and it may be that it is whether there is a causal connection between the fraud, whoever it may have been by, and the obtaining of the judgment.
and
Whereas, would you accept in principle that if, for example, there are two defendants, X and Y, and they run completely different defences, and so there is no material connection, to use that word materiality, there is no causal connection between X's fraud, which obtains a judgment in his favour. If those are the facts, would you accept that actually you wouldn't be able to use this jurisdiction against Y?
I think my answer to that is that to postulate on the different types of circumstances where even that might arise is something which should be considered on a case-by-case basis. But I completely agree that you mentioned a couple of times in debate earlier on that take a case about X and Y, and that's why I say this case is a perfectly proper application of the incremental advance of the law, dealing with new situations as they come before them, because it is, as the judge made it clear 2 or 3 times, he only succeeded because Outlook succeeded, exactly. And we couldn't succeed against him because we could.
That's what I'm driving at.
The direct causal connection.
Yeah,
and I say
you don't necessarily have to hypothesize about other cases which are not before the court. I think you emphasise that in this case there is a clear causal connection, that because Y, to use my terminology, Y in effect adopted the defence of X.
And I've several times thought, what kind of example might there be? Maybe one is a situation where you have someone has taken a loan, and there's some suggestion that the loan is somehow illegal or unenforceable, and you see solicitors who say, I completely disagree, absolutely disagree, and you bring your claim, and the court finds, well, actually the loan was perfectly okay. So the solicitor gets off because his advice was absolutely fine. Then it's found out that actually the loan wasn't because of someone else's fraud. And does that mean the solicitor or the other advisor in some way is simply... So there's the same sort of causal connection, but none of them particularly help. I say look at the facts of this case, which demonstrate not just the fact that he was right to exercise it, but why it has that flexibility and that openness and can't have closed doors, because it seems so obviously right, with the greatest of respect, that where it's that causal connection, that it certainly must be within the equitable jurisdiction of a court with a finding of fraud and a finding of fraud on the court, that it actually displays why the jurisdiction goes that far. John Esco, again, what that says, you've seen it already. If fraud is proved, he said, had it been proved, I agree with the Court of Appeal, the whole judgment is vitiated. And that's when he talks about the insidious disease. And for your, that's page 49. So in that case, they've rejected the fact that fraud had been established, but were it to have been established, then he would have agreed with the Court of Appeal that the whole judgment would therefore have been vitiated, and those words infecting the whole judgment, etc., which we've all seen. My learned friend, so let me just go on to Denning in Lazarus, and what he says, of well known that we all grew up with. At the bottom of page 82 of the authorities bundle, it's not just the word fraud unravels everything. The court is careful not to find fraud unless it's distinctly pleaded and proved. But once it is, then it has very, very far-reaching effects. And so that's, I rely on that passage. And then you have the decision in Clone in the Australian courts. I'm very friend, I think, sought to rely on that to say that actually it shows that you need to have the fraud of the individual party. But I just refer to a couple of passages there. Firstly, paragraph 44 on page 278 of the bundle. And it's the terminology there where he, in 44, in the middle of the page, the distinction between each of the equitable bills is today broadly reflected in the distinction between the power of an appellate court to set aside a lower court judgment and order a new trial, and the power of a court by an original action to set aside a judgment, often of its own, based upon fraud. And again, it's easy to pick on words and say, well, there you are, but it's not procured by or obtained by the specific fraud of another person. At page 283, he talks there about the power of a court to set aside its own judgments. You see the heading at the top of that page. And he explains here the difference between the bill of review and an original bill, and how they have sort of translated into what's now the appeal process and this jurisdiction. And at 53, sorry, at the bottom of 52, as the Vice-Chancellor explained, the former was a separate bill which sought to impeach or rescind a decree of fraud. And again, I very much support the words impeach, as did Justice Kerr, rather than obtained by or procured by. He goes on to say the power of original bill to rescind could be brought without leave, and that's why when one talks about, well, could they have put in an appeal? They can do this without leave. Why have all of those fetters in your way of having to establish why you're doing it out of time, whether you've got to overcome the reasonable diligence test, the fact that you've got all of the cost of the previous action, which you're just going to wave goodbye to. So it left that untouched based upon fresh evidence. It didn't apply to those rules at all. If those conditions were not to be undermined, it was necessary that the circumstances in which the original bill was available be significantly circumscribed. The original bill was commonly described as limited to fraud, although there were different species of fraud. And then this section here, which my friend didn't take you to, the fraud was not limited to a deceit or dishonesty by the opposing party. It extended, in the words of the Lord Chancellor, to a fraud on the court, such as where parties who were not hostile nevertheless presented their case to the court as antagonists in order to obtain orders depriving third parties of their rights. Well, that's, the butcher said, well, I agree with everything Mr. Badgley says, and I accept he didn't plead to certain parts of the defence, but he didn't plead to the oral agreements. Effectively, because he wasn't there. He couldn't say whether there was agreements that if you paid the interest, but he maintained that the case that the 2.6 million was due, the 1.8 million was due, that the money was properly due. So he maintained that. So he was an adversary. And so they've obtained a judgment as antagonists where the court has been defrauded. It doesn't matter, this says, it's not limited to the deceitful dishonesty of the opposing party. It goes further and says in exceptional circumstances, it was possibly to extend to the fraud of a witness. And that's quite a lot further than my only friend suggests, and it's also a very good reason why my submission.
So that suggests that actually all the parties could in fact be innocent, but a witness gives perjured evidence. And that may be a ground.
So that's why you're concentrating on the judgment and whether the court has been deceived, and that's why I think that Mr. Justice Kerr was not happy at all from the very outset about the idea of this is akin to deceit. He said it's not. He said it goes further than that. I appreciate that Master of Law suggested it's akin to deceit, but he said it's not. It's actually going not just the party that's been deceived. It's the court, and it doesn't necessarily even have to be another party necessarily. If that which has led to the judgment is fraudulent, then you can't set a judgment aside against a witness. The judgment's tainted throughout, is what I say. Unless, and without any circumscribed rules, there is found to be an abuse of process in a particular case. Lord, on that subject, let me think that's Takar. The in-law assumptions judgment at paragraph 65, that's 324 of the bundle. And again, I appreciate it wasn't a point for the Supreme Court in that case, but 324, 5 or 6 lines down, the second is not supported by any authority and appears to be an insufficient answer to an allegation that a civil judgment has been obtained against the claimant by the deliberate fraud of another party. Again, it's not ratio, it's just it's an observation, but it's another party. It doesn't say that it has to be circumscribed in that way. And my lord, before I go on to Takar, I started off with a 1838 authority. I have also included in the authorities bundle another passage from Moore, Gummer and Lane, and I didn't realise that you pronounced his name more in that way. I've always referred to him as Meager, but it's the passage which is at, you'll find at page 389, it's internal page 443 of the textbook. And he's just, on the previous page, the authors have been talking about the different types of things which might amount to fraud. And then it says this at the top of page 389, it will be difficult to extract from those disparate circumstances any common factor. This has led various great equity judges from Hardwick to Norton to shew any definition of fraud as difficult and dangerous. In his letter to Lord Kames of 30th of June 1759, Lord Hardwick wrote, as to relief against fraud, and that's where we are, no invariable rule can be established. Fraud is infinite. And were a court of equity once to lay down how far they would go, and I underline the words, and no farther, in extending their relief against it, or to define strictly the species or evidence of it, the jurisdiction would be cramped and perpetually eluded by new schemes which the fertility of man's invention would contrive. But it's really and no farther. It just supports the case-by-case approach where you have already overcome a very, very substantial set of hurdles which are needed to cross the RBS case. I would then take you to Takar. I do so to support the submission I made before that there are actually, despite the courts looking at the question very closely, have not found the existence of any particular exceptions. We've seen, and that's why I say that unless there's an abusive process, the judgment goes against all. Lord Kerr, at page 320 to 321 of the bundle, it's at paragraph 55, and what he does there, he says there might be two qualifications, and he makes it very clear. He's putting them forward as possibilities and not as exceptions. He says in terms that it might be a case where a discretion arises. I make this observation that the authorities in my submission are almost at one in saying this is not a case of discretion. It's more than that. So he says the first is where you've raised fraud before, and the second is where you've made a positive decision not to rely on a fraud that you knew about. But he makes it very clear these are just observations. Lord Sumption disagrees with the idea of the flexible approach put forward by Lord Briggs, but he then goes on to talk about the exceptions that have been, or the types of cases where it might have been, might be some different rule. I've already taken to the passage where he talks about the deliberate fraud of another party. He goes on at 66, I'd leave open the question whether the position as I have summarised is any different, whether fraud was raised in the earlier proceedings but unsuccessfully. My provisional view is that the position is the same, for the same reasons. If decisive new evidence is deployed to establish the fraud, an action to set aside the judgment will lie irrespective of whether it could reasonably have been deployed on the earlier occasion. Now, that to my submission is very material to the question that I've been asked about in terms of could we have brought a claim against Mr. Butch. And this is saying that it will lie irrespective of whether it could have done so, unless, he says, a deliberate decision was taken not to investigate or rely on a known fraud. So he seems to be suggesting that might be one no-go area. Look, I cite in my skeleton argument Lord Briggs's judgment, because in my submission, although there is a disagreement between the judges about whether he was right to say there should be sort of degrees of fraud, he was worried about, well, what if it just creeps over summary judgment or strikeout, but it ends up being a very weak case. But he goes on at paragraph 85, that being so, it's my view wrong in principle to say that the generality are entirely unaffected by questions about lack of reasonable diligence. He says that disagree with. The true principle should be to recognise that such applications constitute the assertion of a legal right with which the court will only interfere if satisfied that the exercise of the right is abusive. And he then goes on to say, I don't think it's a discretion. There should be no judicial interference with the exercise of the right to set aside a judgment for fraud unless the court is satisfied that it involves an abusive process. So questions of, well, could you have done this or could you have done that, in my submission, don't overcome those observations. And so that's what Lord Briggs says. And I say there, he's clearly saying, unless there's an abuse. We then have to go to Finzi. And firstly, Finzi makes it very clear that the only ratio of TACAR was the reasonable diligence point. That's all that is actually decided. And he makes a fairly commendable observation that one's going to be very careful when you're looking at judgments as to how far they're actually going. So he said anything that was said outside of that decision was overturned and not in any way binding. The decision in Finzi itself, which is in fact there in the headnote, is that the trial judge had found that there was effectively no new evidence. You had all the evidence that you needed at the time, and we see no reason to upset that finding. That's the decision in Finzi. And he then, so that paragraph 36, sorry, is his limitations of TACAR, just so you have that passage. I'll just take you through it briefly. That's not 36. He then goes on, sorry, I just forget that record. At 45 to 47, on page 369, he refers to the pleading of fraud, and effectively, I'm not if anyone know that, tell me if I'm wrong, he basically says, we're not at all sure they could prove fraud in the first place, but that's not particularly before us. At 49 is where they say we're simply not going to challenge the judge's findings. So, having examined all the material referred to, the board is satisfied that there was no reasonable basis for impugning the judge's finding that, when he entered into the settlement agreement, he had all the information on which he's relying on to allege fraud. Now, one would think that that means that there's some kind of bright line where you can show that you had all of the information that you wanted to rely on at that time. But in fact, Lord Leggett doesn't agree with that, because what he says is at paragraph 70 is that if the matters relying to support a claim that a judgment was obtained by fraud were known, but were not relied on, the reasons why that was the case will not generally be within the knowledge of the other party, who can only speculate about what those reasons might be. And he then says this very large number of possibilities. And then at the bottom of the page, he says, which of the possibilities accounts for this case, I don't know. But in answering the question, the last two lines, a central consideration must be whether there was any significant impediment to using the material to advance a case of fraud in the original action. If there was not, then prima facie, at least, deploying the material to advance such a case on that occasion would be something which the law would expect a reasonable person to do. Moreover, given that the question of what information they had and why it wasn't used are matters peculiarly within the claimant's knowledge, whereas in fact, he goes on to say it's an objective test. So he goes on to the board considers that where they rely on evidence not adduced to allege that a judgment or settlement was obtained by fraud, the burden is on them to show first that it is new, in the sense that it's been obtained since the judgment, if not, then any matters relied on to explain why the evidence was not deployed in the original action. So even where you have everything, and while it may be the case that the court's going to take some persuasion, that it still is a situation which, according to the board, in obiter dicta, I accept, that the court can still, in appropriate circumstances, set aside a judgment. And it's why it must be right that if those sort of points are going to be made, you had all of the evidence and you should have done this. It should have been pleaded. I should have had an opportunity to. I did as much. We did everything we could. My client put in 40 pages of evidence, which the judge fully took into account and fully accepted as to what he calls about the back and forth of multiple litigation, blood from a stone in relation to disclosure, etc., etc. So even in those cases, these cases say that, having thought about it quite carefully, they've not identified any area which is what I call a no-go area, and why it is the case that the whole judgment goes unless it's an abusive process. And it may be that there will be situations where the cases are so completely different that what the one doesn't follow from the other. For example, they're completely distinct claims. While they've been brought together, one doesn't know, and it's very difficult to start to think what those situations might be. I simply ask the court to look, as we are required to look, at the judgment which was given by His Honour Judge Bird, not to think what might happen in other situations, not to think what would happen if Bird had the information in front of him, what would happen in front of the new judge when we had the retrial. It's just to look at how was this particular judgment obtained. And then I say that the learned judge applied those principles absolutely correctly. At paragraphs 152 and onwards, I think I don't want to beat the drum anymore, but he makes very, very strong findings there at 153 to 155, which we've looked at. At 153, there is no bar, and that's the word, no bar, which prevents the court in an appropriate case from exercising equitable jurisdiction to set aside a judgment against other parties to the original proceedings which are affected by the fraud but not themselves guilty of it. I accept Mr. Bacon's submission that a direct precedent is not necessary to reach that conclusion. If an exact precedent was required, the law could not develop. Equity has an inherent flexibility and capacity to adapt to new situations, and he refers to Millet. The vice of the relevant fraud is that it taints the impeached judgment. It is not done to punish the frauder, but to protect the integrity of the process. And I submit that he's quite right to say the tests are not directed at the parties, but at the impeached judgment, and they address the grounds for setting aside, not the identity of the party or parties against whom it must be set aside. Now, that's obviously his own. I say you should not only agree that the jurisdiction exists, but strongly endorse his approach. I don't. It's not particularly necessary, but the observations at paragraph 156, I'm not sure necessarily correct. I don't think it affects his judgment, but he says, well, of course, their innocence or otherwise might be something which goes to the actual jurisdiction of the court. I think, well, again, I don't accept that as a matter of general principle. It may be an individual case, but if the reason for that party succeeding is another party's fraud or a witness's fraud or a fraud on the court of any description, then I'm not sure that different levels of fraud or different levels of innocence or culpability are helpful. Indeed, the courts have regularly said they're not.
I may be wrong, but I'd understood the judge's point there as being that if the party concerned is the fraudulent person, X in my terminology, yes, then if other factors are brought into the equation, like passage of time and so on, the court might be much less sympathetic to that person. So I'm not sure the judge is saying any more than that the fact that the party is Y, an innocent party, may be relevant to the exercise of the jurisdiction.
In terms of, and of course, firstly, his exercise of discretion once you've got to the jurisdiction point is not part of the appeal.
Right.
But in any event, he gives very, very clear reasons why he doesn't think it's inequitable, and he refers to them all in his judgment. He starts off by saying the fact that Millennium Friends' clients are insured. And I mean, I observe only that my clients are having to fund these cases themselves. They haven't got a penny back. They've got some money back from the previous trial. But Millennium Friends' clients spent £250,000 on this appeal, which it puts us in the same position as we had with Outlook, just trying to destroy us with costs. But he made the point, you are still insured. You haven't lost your insurance. There's no detriment there. He then makes quite critical observations, or he makes it clear that he's not making any findings of fact about having been advised. Just to run through those, I don't think there's any particular point taken about it, but 169 of his judgment, page 73. Barely 5 hours after being appointed, he was warned to obtain a court order. He must have known that forced entry would be likely to be controversial. With surprising insouciance, and unlike his Scottish counterpart, Mr. Woods, he pressed ahead regardless, ignoring sensible, objective legal advice to the contrary. On the 26th of November, well, that's 5 days after he's taken possession, he had evidence that MBDFL had ceased supplying milk on the 1st of January and that the supplier was DM Lindsay. And Mr. Lindsay's witness statement and under cross-examination, he said, we told them it was DM Lindsay, we kept telling them it was DM Lindsay, and they ignored us. He was then given further advice and the judge makes the point that he wasn't an expert in cattle. What he basically said was, I left everything to Mr. Brooksbank, who was an auctioneer, and the judge was very critical of that. But he was then told again that he might have duties as bailey of the cattle in relation to any cattle that didn't belong to MBDFL. And in paragraph 173, in January, he was once again warned about the risk of liability for conversion, and he had further matters in correspondence with HMRC, where he was trying to work out if there was some kind of tax benefit, that actually they had nothing under MBDFL because everything was registered under DM Lindsay. So he was saying, I really can't see how it can be inequitable in those circumstances where we've never had an opportunity to have a determination of our claim on the merits as a result of that original fraud. Well, I think I've probably made these points sufficiently, but the suggestions within the appeal and the application for permission that there was no new evidence or had all the material before, I think I've dealt with that. And I also say it's no part of the appeal in any event. Lord, I think in those circumstances, that's my submissions in relation to the permitted ground. Yes. And that effectively the law is that where you have judgment obtained by fraud, it doesn't matter which party it is, but you don't need to go that far. You can say that in the circumstance before us, there's no dividing line, there's no absolutely dark line which says we can't go there at all. And once we get to there, then the equitable jurisdiction exists in relation to other parties in appropriate cases. It doesn't need to say it will always be the case, but in appropriate cases, and this is an appropriate case. Late fees, permission to appeal and appeal. I mean, I say you should reject notion of giving permission in the first place. A number of my submissions have been rather rendered unnecessary, but in a way that's not particularly satisfactory in my submission. It's the way in which the case has changed. That the appeal is put forward very clearly on the basis that the detriment that's now being relied upon in this appeal, it's all very well from an own friend to say, well, I'm still relying on the original detriment. The detriment he relies on this in here is Mr. Butcher not having kept hold of or being able to access what he calls critical documents which could assist my defence. That's the appeal which I think I have to meet, and I make the points I made in my respondent statement and in my skeleton argument that is unpleaded. There's no application to amend the pleaded case, and there's no witness evidence to support it, and that plea cannot possibly be supported other than by evidence, because Mr. Butcher needs us to tell.
Isn't pursued.
I'm sorry?
That isn't pursued.
Well, yes. Well, I think we say that if it's not pursued, then actually you should refuse permission, because that's the detriment which they say they're relying on for the purpose of the appeal. There's no suggestion in that document that we rely on both. In terms of the original plea, I just want to make sure the court's familiar with how we got there, if you like.
Well, it might be worth, given you've made that point, looking at how the ground of appeal is actually framed. So we find that in Core Bundle tab 1 at page 15. So ground 2 is as follows. The judge was wrong in fact and law to hold Mr. Butcher could not succeed in his defence of late cheese in circumstances where the claimants had admitted to having delayed issuing proceedings against Mr. Butcher for many years, whilst pursuing parallel proceedings in Scotland in which fraud was alleged against the first defendant. So that's how the ground of appeal is actually framed.
Yes.
Nothing about
Nothing about any of that.
critical documents there.
Firstly, it incorporates the statement that we had delayed issuing proceedings against him for many years while pursuing parallel proceedings in Scotland. They weren't parallel proceedings, they were proceedings which were separate to what was brought in Scotland. They were a claim to set aside the mortgages in their entirety. And they were successful in that respect, and also the original loan agreements. I'm not sure whether that means that we also ignore the originally pleaded detriment, because that's I take on board the points made by the court about what would have happened if he'd have spoken to Mr. Franchley. And I also make this observation: Mr. Franchley is not Outlook. Outlook was the party here. Outlook, after Mr. Franchley's death, brought further proceedings against my clients to try to make them bankrupt, to follow up on an indemnity. And when we issued our declaratory actions, and this is all in that How We Got to Lady Wolf section, they asked for a debate, which in our language is an application to strike out. When we brought the second declaratory action, they brought another action to strike that out. This is not Mr. Franchley. This is Outlook. Outlook maintained throughout the Scottish trial that all of the numbers were right and that money was still owed. And Mr. Butcher maintained that until my learned friend got on his feet in his closing submissions. Because his pleaded case, if you look at his pleaded cases, he says, not only does he say, I agree with, I don't accept that Mr. Franchley or Outlook were in any way dishonest. He actually pleads, it's not Judge Baird was right and Lady Wolf was wrong. Directly pleaded against us. So, but in terms of the way that is that is put, I think I put it this way: the passages I've shown you don't in any way prevent us. It's a substantive right for us to bring this claim. What you still have a situation where they have to establish. Certainly, the authorities show that detriment is still part of the cause of action, unless you have a waiver or an acquiescence where you've actually made the other party actually think there's nothing more going on. Then prejudice is delay on its own is not enough. And if I can just show you in my, because of the way that this case, I put in a very detailed separate skeleton on late cheese, and I now need to find where it is. It's in the supplemental bundle. I think it's tab 9. It's yes, it's tab 5 of the supplemental bundle. It starts at page 81. I'm not going to. You've already seen the first passage. You had that read out to you. That's from Lindsay, Petroleum and Herd. If I just ask you to go forward a few pages, I cite also from Snell at paragraph 15 on page 83. And it's talking about the maxims of delay defeats equity forward, agent vigilant and not the indolent. The doctrine is not based, however, on the mere fact of delay. Something more than mere delay, even more than extremely lengthy delay is required before B will be denied equitable rights under the doctrine of late cheese. As the question is whether the lapse of time has given rise to circumstances that now mean it would not be inequitable to deny relief to B, that should be a capital B. The principal example occurs when, for example, perhaps as a result of having relied on a mistaken belief, they would never suffer an irreversible detriment as a result of delay. Sorry, I read that wrong. If B were permitted relief, sorry, I've read that completely wrongly. This principal example occurs when, for example, perhaps as a result of having relied on a mistaken belief that B has no relevant right, they would suffer an irreversible detriment as a result of the delay, if B were permitted relief. The doctrine will therefore apply if the delay has resulted in the destruction or loss of evidence by which C's claim might have been resisted, or if they can be said to have released or abandoned any right. There can be no abandonment of a right without full knowledge, a legal capacity, and free will, so that ignorance or disability or undue influence will be a satisfactory explanation of delay. So it's certainly not mere delay, and it's emphasising the fact that one normally has to have detriment. It talks about the possibility of, you're talking about destruction or loss of documents. That was something which was alluded to in the skeleton, but not now pursued. In terms of the, just to be very clear on the evidence, again, if the court needs me to show them, I can, but Mr. Butcher signed his witness statement on the 25th of June 2025, and that's at, we're in the same bundle, page 243. It's the very end of sub-tab 3 at the end of that bundle. So that's the date he signed his witness statement. If you then go back, if you want, to page 74, the 74 is the date of our application to amend our particulars of claim. And that's the 27th of June. So what had happened was witness statements were due on the 27th, and we made an application to amend. We said to the other side, can we delay witness statements? They said no. And Mr. Butcher put this witness statement in, and his witness statement makes no reference to Lindsay's other than this broad reference to 10 years. It's all taken 10 years. And he did not attempt to address that in a subsequent witness statement. And Lord, briefly, if I may, on the extracts from the day 1 of the hearing, and that's at tab 7 of this same bundle. At first, I don't think there's any dispute about this, it was found that many friends suggested that late Master Sullivan had given him permission already, and it was found that that wasn't right. She'd only given permission for consequential amendments, and late she was not consequential. So,
what page are we on?
we're on page 95 of the supplementary bundle. I'm very sorry.
Oh, thank you. Yep. And internal page number.
Internal page number 36, where the judge says, sorry, I say at line 12, they need to set out the proper, actually what delay they're relying on and what they say they relied upon. So you'll just say they're moaning generally about delay. Yes, I am. Yes. So we say there's nothing about what the period of delay is. We say nothing about what his position was before he altered it. Says nothing about the position after he altered it. In other words, what change of position is relied on? And I say just moaning generally about delay is simply not enough to make the defence a properly pleaded one. Judge then says, I guess until they were served, he didn't know about it. And I said, we don't know. He said, well, if you did, then, and he stopped. He says, but it's true, you're quite right to say there's nothing. I haven't seen anything in the pleadings or witness statements which said I did X in reliance on this matter having gone away. So he's very aware of that. And then over the page in the bottom left-hand box, line 4, sorry, let's just go back to 25 at the top left-hand. Mr. Justice Kerr says, so far I think you're speaking eloquently against the point succeeding rather than convincing me that it shouldn't even be entertained. And I say it should not be entertained because it needs to give me the ingredients. He said, well, that's remediable. Mr. Banks-Jones will give a few lines of further information. What period do you rely on? What acts do you rely on? What omissions do you rely on? And then it would then be a sustainable plea saying nothing about whether it has any merit. So what then happens is the judge says, well, this is on page 97. And the judge asks Mr. Banks-Jones whether he thinks that the late chief's point was consequential. He found against him on that. And then Mr. Justice Kerr says on internal page 57, I had that look. I don't want to detain you too long because I'm actually not against you in principle, despite the eloquence of Mr. Bacon. However, I am sympathetic to his point that you ought to particularise what the period of delay are, the detrimental reliance you rely on, and I would have thought to allay any concerns of the kind that Mr. Bacon mentioned, that you would not be likely to get my permission to put in any further evidence. It would have to be done on the basis of the witness statements as they stand, and if you put new points in cross-examination, I might stop you effectively. And then, just as we rose at page 99, line 8, I'm not going to give a reasoned judgment. I'll include some reasons in my main judgment. I've indicated I don't think it would be right to shut out the plea, but I do think that it should be properly particularised, and that needs doing today, tomorrow, overnight. And Mr. Banks-Jones, you'll have to address the points made by Lord Selborne and Lindsay Petroleum on the front page of Mr. Bacon's skeleton on this point. So it was made pretty clear that they were asked to do that. And what we got, albeit what's it, page 91 and 92, is what is stated to be a second defendant's plea as to laches and detriment. And I just make the observation, there's no statement of truth. There was to the, of course there was to the re-amended defence, but there's no statement of truth to this. And they were told in no uncertain terms that they had to set out for me what case it was I had to answer, and it wasn't anything to do with what's being put now about not pursuing them for a number of years. It's about not being able to speak to Mr. Fradgley and be able to check with him the documents which they rely on. And so I simply say it's a point that was never taken in the original at trial. And that the findings that the judge has made are numerous and factual findings which are not challenged. I think I can probably assume, are your lordships familiar with the part of my learned friend's skeleton where he says that the judge wrongly used Hollington and Hewthorne in relation to the defence of Laches?
Again, that wasn't pursued.
I'm assuming that's simply not pursued. I mean,
Well, it doesn't arise. I mean,
there we are. That cut short those submissions.
by that I mean Hollington Hewthorne clearly has nothing to do with leeches, but that's not the way I approach
see.
the leeches argument.
Well, my lord, in that case, I'd better briefly deal with it. He's referring to paragraph 176 of the judgment, if I remember correctly. Yeah, it's page 74, 176. I also reject the defence of Laches. The efforts of the Lindsays were sustained and unrelenting. The process was time-consuming through no fault of their own. Obviously, I rely on those findings as well. The ruling Hollington and Hewthorne doesn't assist Mr. Butcher because the findings of fraudulent conduct made by Lady Walter Bonny on Outlook, and they're directed at Outlook and not at Mr. Butcher. They're not relied on by the claimants as against Mr. Butcher because they don't accuse him of fraud. So, I mean, my submission, that's a self-contained point out of Hollington. But the time it took is a good answer to the defence of Laches. And my lord, I say that that is a clear dealing with what is put to him by way of submissions, in which he summarises at paragraph 135 of his judgment, which you will find at page 68. Because in fact, those points are put to him in submissions together, if you like. What's said there is the Scottish these are my learned friend's submissions about the Scottish proceedings were irrelevant except as part of the chronology of events supporting the plea of Laches. On the authority of Goddard, remarks in the judgment for Hollington and Hewthorne, Mr. Banks-Jones submitted that it is settled law that a judgment in earlier proceeding to which an individual is neither a party or took part can have no probative value as regards that individual in subsequent proceedings and is not admissible as evidence against them. So in other words, these are the 2 points that he's making about the relevance of the Scottish judgment. One, that you can't use it to in somehow render Mr. Butcher liable for the fraud of another or in any way affect Mr. Butcher, but it doesn't. And the second is that it was relevant to the chronology of events in relation to the plea of late cheese. And I say paragraph 176 is manifestly actually just responding. He set out what his submissions were, and he's responding to them. He puts them in the same paragraph, but he's saying, I think the Scottish proceedings, that they're wrong to say that Hollington and Hewthorne helps them on the Scottish proceedings, but I agree with Mr. Bacon that the time it all took was not unreasonable. And the other point my friend makes about that paragraph 176 is that it's the only place that the judge in any way explains why he's made the finding that the defence of late cheese doesn't succeed, when actually I say he's referred to how we got to Lady Wolfe and how he says I fully accept those findings, etc. That's clearly what he's rowing back to when he says I reject the defence of late cheese. So, well, that's I think all I really want to say about Hollington and the Hollington and Hewthorne point. Those findings, if I just ask you to go to paragraph 68 of the judgment, so because there's an area where I say that he has dealt very clearly with the timing point. Page 54, where he says, Roger gives a detailed chronological explanation of in his lengthy witness statement of how we got to Lady Wolfe. His account includes the twists and turns of multiple legal processes, including, amongst other things, and he sets out some of the factors which came into play, including a war of attrition, and number 7, a battle to secure access to the documents, unsuccessful attempts to appeal, an attempt to obtain original documents so they could be examined, and then eventually the instruction of the accountants. I take that detailed account fully into consideration, but I needn't repeat it here in the same level of detail. I can take it more briefly. In late 2014 and 15, Outlook brought 3 actions in Scotland against Euan Estates and against William. The basis on that was that they were indebted to Outlook for the loans and unpaid costs. Possession of Harperfield was sought amongst other remedies, and then in 2015 they found that they should get the bank statements. Then he goes on to explain how things moved on from there. But he summarises it. He says, I'm not going to go through all of it because it's 30 odd pages long, but I have it very much in mind. And that's why when he comes to the decisions, I don't think it took too long. I think they fought on with tenacity and vigour, etc., etc. That's what he's referring to. And he makes it very clear that that factual account was not challenged. When things happened and why they happened, it wasn't challenged in my old friend's case. It was because they were the events which happened. Well, could you just give me a few moments to just go back through my notes and make sure there's nothing else that I want to, and obviously I'll then give you, if you want to say anything. No, I think I endorse the issue raised by Honourable Justice Arnold about what the period was. Are you saying it was late cheese to 2017? Are you saying it was late cheese for which period? And firstly, incredibly difficult to think what on earth Mr. Fraggy would have said in response to help me here. what are we going to? What do you say about these documents? In fact, everything supports the fact that Mr. Butcher would have said, "Well, I completely agree with you," and I trust you to the fact that you're right. But in any event, what difference would it have made? And Outlook is Outlook. It's not Mr. Franchley. And as the judge made that finding, he said they pressed on regardless after Mr. Franchley's death. Lord, because of his encyclopedic knowledge of this case and the fact that he's travelled all the way down from Scotland, can I just check with my client that he doesn't have a few points he wants anything to raise? No, two things. Firstly, I wanted to express my gratitude to the court for having a fixed start date to accommodate Mr. Lindsay coming down from Scotland. But he just asked me to emphasise the fact that the court he asked them to take into account what he and his family have been through over the last 10, 11, 12 years. And to balance that, if you like, against the fact that there were documents available, not from, well, they may have been available to Outlook as well, and that's why we say we relied on them against Outlook in the trial, which Mr. Butcher had from the advices that he'd received and the factors which he knew, which may very well have not led to that 12-year delay. We'd have been able to plead our case, which we'll plead now at the retrial, provided we're given the opportunity to do so. We'd have done it 12 years ago. He wants me to emphasise that point to you. But, Lords, are there any matters that you want me to address? Which
May I just check if there are any other questions? No, thank you very much, Mr. Baker. Yes, Mr. Warden.
I hope I can be brief, but I only want to make one observation about the first ground of appeal, and it may be you'll need a note, but I'll explain why in a second. I was slightly troubled by the footnote number 72 to the clone case, which suggested that you might be able to set aside a judgment because of a fraud of a witness by perjury. We've seen that on page 284 of the Bundle of Authorities.
Sorry, where are you?
Bundle of Authorities, tab 12, page 284. And it was the last sentence of paragraph 53 that gave me cause for thought, because if that is a correct proposition, that might undermine my primary submission. So, in the short time available, you'll see 4 cases cited in 72.
Yes.
So I've looked at, in the following order, I looked at the most recent SZFDE, then I looked at McDonald, then I looked at capacity. And what I've come up with is as follows, which is possibly why you might need a short note. In SZFDE, what the court says is that, put it rather differently, it has been said in this court that accepted very exceptional cases, fraud constituted by perjury by a witness acting in concert, is not a sufficient ground for setting aside a judgment. And there's cited McDonald and Compassi and Villa. If you go to McDonald and McDonald, though, you find that that was a case where the witness gave perjured evidence in conjunction with and at the instigation of the defendant. And so it was clearly the fraud of the defendant on the court, not a self-standing right to set aside a judgment on grounds of fraud by an independent witness. Then Compassi and Villa was a strange case. It was an assault case, and the claimant failed. She then sued one of the witnesses, not the defendant, for basically giving perjured evidence, held no cause of action. There was some very brief discussion about obiter to the effect that any claim against the witness couldn't succeed unless the judgment against the defendant was set aside. The judge agreed with that. I no doubt great difficulties confront the appellant on the case made in the statement of claim for setting aside the judgment on the ground of fraud, but I'm not clear that the Judicial Act is not flexible enough, but I make no comment on it. It's not part of this case. So none of the cases cited show a self-standing right to set aside a judgment on the ground of fraud on the part of a witness with which the defendant is not implicated.
Right.
So that's all I wanted to say about that. A few observations on late cheese. The evidence before Lady Ford and the evidence from the witness statement shows that by 2016 they had sufficient material to make an application to set aside the judgment on the grounds obtained by fraud. In particular, the documents I've taken you through already, I don't need to repeat that. They had the admitted lies to the bank, admission being made in a statement in 2014. They had the forged minutes. My learned friend tried to convince you that the documents, the box of documents, was peripheral. But that, you will recall, the evidence was that Fragilely sent all the minutes over on a contemporaneous basis. And that box of documents contained the minutes. The evidence they gave in Scotland was it was clear from the minutes that what those minutes said was untrue. They would have known that in 2015, and they certainly knew it by the time they issued proceedings in Scotland. And they also knew that there was a forged signature on one of the minutes, and they also knew that they had received copies of altered documents, which is a clear evidence and badge of fraud. And all that material was in their knowledge and in their hands when they started the declaratory proceedings. Now, my learned friend says, well, they didn't amend to allege fraudulent misrepresentation until later, but effectively the same material was being relied on, with the sole exception of the accountant's report that they obtained in 2019. But all the material they had justified an allegation, a cause of action to set aside the original judgment on the grounds of fraud. My learned friend, in answer to the question, said, we've had to get judgment against Outlook first. Why? Is what I would say. And I said there was absolutely no basis to justify that submission. Going on to detriment.
Sorry, can I just ask this? I understood from Mr. Bacon that what they didn't have until 2019 was material to establish there was a deceit about the amount owing.
Yes.
That's right, is it?
That's right. That's in the accountant's report. But that doesn't detract from the fact that they had evidence of fraud before then. And they had evidence of fraud before they issued the 2016 and 2017 declaratory actions. My own friend then deals with detriment. Rather oddly, when the judge gave permission to amend, he refused my learned junior to adduce any further evidence on the question of detriment. And so the issue was dealt with just by the particulars that you've seen. Importantly, the judge does not say in paragraph 176 that the detriment has not been made out. Being very technical about it, if my learned friend wanted to run this argument on detriment, he would need a respondent's notice.
Well, but why? Because the judge doesn't say that there is detriment, either.
It's implicit. We say in 176 that there is detriment. Perhaps we ought to look at it.
Shame in that.
Of course. So the sole reason the judge, so it's page 74. I also reject the defence of late cheese. The efforts of the Lindsays, particularly Roger, were sustained and unrelenting. The process was time consuming. Then we deal with Hollington and Hewthorne. And then he says, but it took time to obtain those findings as a good answer. He doesn't say, I'm rejecting the defence of late cheese also on the ground that no detriment was suffered. He's recorded the submission that
It doesn't say there's detriment, he accepts detriment either. I mean, more specifically, and this is, I think, could be said to be a neutral point, I don't know, you might even say it's in your favour. He doesn't specifically address the case that was pleaded in the supplementary particulars, which is all about Mr. Fragilely having died.
No, he doesn't.
He does. But presumably you couldn't say that he's thereby accepted it. You might criticise the judge for not having dealt with the pleaded case. But he hasn't accepted it, has he?
Well, he did record what my learned junior submissions on late cheese. And one would have thought that if he was against my learned junior on the question of detriment, he would have dealt with it at 176. I accept I may be overreaching myself in saying it's implicit, but he gives one ground and one ground alone for rejecting late cheese, saying they did all they could. And if you look at the case on that basis, it's quite clear that they could have issued proceedings against Mr. Butcher years before and chose not to. It's also quite clear they didn't tell Mr. Butcher about it till the letter before claim. A small point, my learned friend misspoke. The letter before claim was December 2022, not October, but nothing turns on the difference in the date. My learned friend sought to sort of derive some comfort from additional documents disclosed by Mr. Butcher. The discussion at that starts at paragraph 43, but in paragraph 88 of the judgment it says no reason for thinking that any of these documents should have been disclosed in the first action, and importantly, the new documents don't go to the issue that he had to decide whether or not there was a fraud in the original proceedings and whether or not Mr. Butcher was party to that. So, unless I can help you any further, that's my reply.
Is there anything else?
So I'm still just troubled by this point about the case that was pleaded in the further particulars.
Right.
And I was just looking at the recitation of Mr. Banks-Jones's closing submissions. I'm not totally sure it's dealt with there either. Oh, no, it is. It's 126. 126 is where it's mentioned.
Of the judgment.
Yes.
Thank you. So, but the judge doesn't come back to that in paragraph 176. So I assumed from 176 that the sole ground relied on by the judge in rejecting the defence of late cheese was that it was reasonable for the claimants to proceed in Scotland first, but only against Outlook. That's how I read 176. And that's why I said it was implicit in that he wasn't rejecting an argument of detriment.
Well, I hear your submission on that, but can I ask you about this hypothesis? I'm not making up my mind, please understand.
No,
I'm
of
just
course.
trying to explore,
No, of course,
explore the argument. A possible reading of 176, perhaps, is that he doesn't address the submission in 126 because he doesn't think it's necessary to do so, because having decided that there's, my paraphrase, no unreasonable delay, he doesn't consider that it's necessary to decide whether there's detriment or not.
That's equally plausible. I have to accept that.
But if that, and I emphasise if that were the correct interpretation of the judgment, would that reveal any appealable error?
No, the appealable error is what he says in 176, and if you're with me on that being an appealable error, then you have to consider whether on the material before the court there is sufficient evidence of detriment to make out the defence. And I've addressed you on that.
Right, that I understand. Thank you.
The only thing I would say, I've been trying to find it, but there's a sentence somewhere in the judgment where he makes the point that despite the fact that Mr. Fradgley died, Outlook is Outlook, and Outlook continued to both pursue the actions that they had brought, defending the actions that were brought against them, and bringing further procedures against the Lindsays. And so I just couldn't find the sentence in there. If you want me to send you a short note.
No, it's all right.
I'm sure you'll find
You've
it
made
through.
that submission. and we'll look again at the judgment.
I'm very grateful.
So the last word, if I may, the fraud alleged was the fraud of Mr. Fradgley. The fact that the entity Outlook survived his death isn't really the point. It was Mr. Fradgley was the person who needed to be spoken to by Mr. Butcher. It was Mr. Fradgley's documents that needed to be discussed. It's Mr. Fradgley's minutes. And I'm not asking you to speculate, but it's very odd, isn't it? If Mr. Fradgley really was the fraudster that Lady Wolfe has found him to be, that he'd be sending false minutes contemporaneously, setting out a position that was blatantly false. But I'm not asking you to speculate.
Good. Right, is there anything else? Any other questions? No, thank you very much. Sorry, Mr. Baker.
No, just I meant
Thank you all very much, not only to the advocates we've heard from, but for those assisting them to prepare this case. We will reserve our judgments. Drafts will be circulated in due course to those whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors and agree a draft order so far as possible. If that's not possible, they must file brief written submissions so an order can be finalised at the same time as hand down. I must emphasise, particularly for the benefit of those who are not familiar with the court system, that circulation to the parties or to any other person for those limited purposes will be the responsibility of solicitors, and any such circulation is for those purposes only, and any other publication may be in breach of the confidential embargo on the draft judgment when it's circulated, and this court takes extremely seriously any breaches of that confidential embargo.
Understood.
Understood entirely. I just so the court is aware, I am, perhaps unusually, I'm instructed on a direct access basis. I
Yes.
fully accept that that entirely applies to
No,
me.
thank you for reminding us.
My solicitors, obviously, they've assisted very much in terms of the background work and the bundles and everything else, but I am instructed on a separate direct access basis. But of course, I accept that I'm one of the persons on that list, and I have that
Very
duty
good.
just as much.
Thank you very much.
All rise in favour.